Thank you. Please be seated. First case for argument today is 355 People versus Mark Smith. Good morning.
Good morning, Your Honors. Stephanie Stair for the appellant, Mark Smith. I'd like to spend my time discussing points 1 through 4 and rely on the brief for the remaining points. Point 1, the police here acknowledge that they arrested Mr. Smith solely on the basis of the Crime Stoppers report. However, that report did not provide probable cause to arrest Mr. Smith. Aguilar-Spinelli requires reliability and a basis of knowledge, and absent that basis of knowledge, corroboration is required. The informant here had no basis of knowledge, no corroboration, and her information was unreliable. She claimed...
She knew the defendant.
She did.
Interacted with him quite frequently.
Correct?
Quoted him, so those would be theoretically admissions. And the corroboration, one could argue, and this is, I'm just floating it out for your consideration, for your retort, is one could argue that the corroboration with respect to the information for the tipster came from the facts of the crime.
You're right, Judge. However, the location that she claims Mr. Smith confessed to robbing was a different location that was actually robbed. We're talking about Monroe Avenue versus Park Avenue.
They're not far
But they're
apart.
not far apart, are they?
Correct, but they are different locations. Additionally, she claims Mr. Smith admitted to a future second robbery that never happened. And that location was staked out by law enforcement, and it never happened. When he was spotted and stopped by the cops, or the police, excuse me, he was not engaged in any criminal activity, and anything that came after his arrest, the items that may arguably corroborate the informant's report weren't obtained until after the search warrant was issued, after he was in custody. Your Honors, I think this point is inextricably linked with point 2, which I will move to if there are no further questions on point 1.
That has to do with the mistake you just referenced.
Correct.
And you're wondering why the heck counsel didn't bring it up during the evidentiary hearing before trial.
I sure am.
Can you think of any strategy that would warrant it?
I cannot, Judge.
What about maybe making use of that trial as he did?
Well, I think it can be gleaned from the record that he hadn't even reviewed it. So he goes into the suppression hearing saying, I don't have this. The ADA tells him, I emailed it to you at this time, and he says, okay. So I think it can be reasonably inferred from that he hadn't reviewed it. He didn't even know he had it. So I think that makes it very clear that there's no strategic reason not to go there.
But you don't know that he didn't have it. He said, okay. He didn't say, I don't have it.
Your Honor, he did say, I don't have it. She said, I sent it to you, and he said, okay. So I think his belief was that he didn't have it. She pointed out that he did, and he agreed, okay, maybe I have it, but I think it's pretty clear that he hadn't reviewed it prior to that suppression hearing.
Well, it's possible, though, that if the question had been asked or the issue pursued, the investigator would have said, well, we looked at, there were no other robbers at any salons on Monroe Avenue. There's no other salons on Monroe Avenue. We looked into that. Usually if a hair salon is robbed, they're going to call the police. And it may not have really led anywhere.
It may not, but we don't know that, Judge, because it didn't happen. He didn't investigate it. He didn't, as I said, it's pretty clear he didn't even have it or review it at that point. So he didn't even go down that alley at the suppression hearing. And in fact, Mr. Smith, expressed his concern about his representation following defense counsel's performance at that hearing, and that's covered in point 5.
I think it goes back to your first point. If you're right that the difference between Park Avenue and Monroe Avenue is significant, then he was ineffective.
Correct.
If it's not, then it's not. There was no harm in him not exploring that issue. And so we'll take a look at it in the context. But I think your argument on the first point is that regardless of the location, there was no reliability or basis of knowledge, even if we don't think it's significant, the difference in Monroe versus Park Avenue.
Correct.
you want to address your third issue?
I do, Judge, thank you. The court below erred in allowing the alleged admissions regarding that future planned robbery as Molyneux evidence. These were not prior bad acts. They weren't acts at all. They were just statements. Even if you were to find that it qualifies as a prior bad act, the prejudice far outweighs the probative value. The prosecution argued it was relevant as evidence of MO, but there's nothing unique about the method by which the salon was robbed. They also further argued it was needed to complete the narrative. However, this was a single isolated incident. It's not like the DV cases where you need background information to understand the incident.
Well, did it not help your client at the trial? You know, there was the theory that he was going to rob this other place, and he never did. It seemed to undermine the reliability of the informant there.
It might, Judge, but I also think because the rest of the evidence was not overwhelming, that I think it gave the jury a statement like, you know, if you have questions about this future or this current robbery, he was going to do it in the future, so you should believe this. You know, that kind of that suggestion to the jury.
Was that testimony relevant and competent?
I would argue no. It's included in the Crime Stoppers report, so it has the same lack of reliability as I argued in the first point.
So, but that's a weighing analysis. I'm looking at relevancy. You would agree the statements by the defendant that he's telling to the tipster that I'm going to do it this way and I'm going to do it the same way I just did it. That certainly sounds relevant. Don't you agree?
I would agree it's relevant, but I think it's highly prejudicial.
Okay, that's different, but it's
Okay.
competent also because it's an admission, a statement by the defendant reported to the person who testified. So it's not hearsay, or at least falls under an exception. So your thinking is we have to weigh that. So, but we can still fairly find that it's relevant and competent, and all relevant and competent evidence, as Richardson would tell us, is presumably admissible. So you're saying we would have to simply look at the prejudice in order to exclude that, correct?
Yes, but I don't think you can completely ignore the fact that it never happened and that it's not an act. It's not a statement against penal interest. It's not a robbery that's already occurred. It's something that he allegedly said he's going to do in the future that law enforcement followed up on and confirmed never happened. If there's nothing further, I will move to point 4.
Thank you, please.
Thank you. The court below erred in not granting a mistrial based upon certain statements attributed to Mr. Smith being elicited for the first time at trial. We do recognize that a 7-10-30 notice need not be a verbatim recitation of statements. However, it must adequately allow the defendant to defend against those statements. Generally, or quite often, 7-10-30 notices will be of the quote-unquote see attached body-worn camera or see attached CD ilk. This was not one of those. It delineated specific statements. The trial court agreed with defense counsel to the extent that listing out those specific statements gave the illusion that that was an exhaustive list of the statements that would be elicited at trial. The illusion was furthered by the fact that those same statements were the subject of the Huntley hearing and in the police officer's reports.
So which specific statements of the defendant do you think should not have come in or outside the scope of the notice?
The statement that said, if you had anything, you would have picked me up a long time ago. That came out for the first time at trial. The police officer admitted it was not in his report. It was not mentioned at the Huntley hearing. The court below found that the defense was put on notice because the statement was included in the body-worn camera footage. However, the witness's failure to mention the statement at the Huntley hearing deprived him of, Mr. Smith, of a full and fair opportunity to challenge it. This court in Reed, which is mentioned in the brief, ruled that a statement made for the first time at trial did not require reversal because it didn't prejudice the defendant. In that case, the defendant had admitted to stabbing the victim and then put forth a justification defense. So further admissions regarding the stabbing weren't prejudicial. I would submit that this is wildly different in that Mr. Smith consistently maintained his innocence, so a statement that's tantamount to a confession is certainly prejudicial. And if there are no further questions, I'll rest on the brief for the balance of the issues.
Thank you.
Thank you.
Morning, Amy Wallensack on behalf of the people. Unless the court has any questions about points 5 through, I believe, 8 of my brief, I'll plan to address points 1 through 4 as well.
Could you start on that last issue?
Sure.
Do you agree that the statement at issue, quote, "If you had anything on me, you picked me up a long time ago." Do you agree that that was not included in the 7-10-30 notice?
It was not specifically delineated in the 7-10-30 notice. It was on the body-worn camera footage, which defense counsel acknowledged receiving and reviewing prior to the suppression hearing. And
But
with
the
respect...
notice is supposed, I mean, you can have a lot of things on a body cam video, but the notice is supposed to advise the defendant, this is what we intend to use out of all those statements you make. This is what we intend to use. And the notice didn't say any and all statements on body cam, right?
I don't believe that it had that exact statement. I would defer to the record on that point. However, a defendant also waives lack of notice preclusion if he's granted a Huntley hearing and is given the opportunity to challenge the voluntariness of those statements at the hearing, and here defendant was. We had the Huntley hearing, and the gist of that statement was brought out during the hearing. I believe the officer testified that as they were transporting defendant to the public safety building, defendant made not only the statement that was specifically referenced in the 7-10-30 notice, but he also said, "You guys don't have any evidence or anything on me." That was the gist of the statement, I remember. I would, of course, defer to the record for the exact phrasing. So at that point, defendant has the opportunity to challenge the voluntariness of, the "you don't have any evidence on me" statement, and he didn't avail himself to that opportunity at the hearing, and that therefore waived the lack of notice argument. I would also note, too, with respect to the mistrial motion, defendant did not object to the statement at the time that Officer Cushman testified to it during trial. He moved for a mistrial on the next day, so his motion was belated.
Would harmless error apply if we were to find an error on that?
I believe so, because in the people's view, this statement of "you guys don't have anything on me, you would have picked me up a long time ago" is far less damaging than the other statement that was properly admitted. I believed it was, "They probably found the gun. I'm really in trouble now." And unless there are any questions, I'll address point 1. It's our position there was probable cause here to arrest based on Ms. Schlafer's Crime Stoppers report. As an identified citizen, she's presumed to be reliable. And it's not required that she personally observed the crime. She needed to have a basis for her knowledge, which she did here. The perpetrator of the crime confessed to having committed it to her. And I believe we cited to a third department case, Cuso, I apologize if I'm mispronouncing that, in our brief, and it was a very similar situation where probable cause was found based upon an identified citizen's report based upon the defendant's confession. And with respect to point 2, it's our position that the street name discrepancy is relatively minor. The two streets here at issue are, I believe it's 2 city blocks apart from one another. This isn't a scenario where she testified that she knew about a robbery in, say, Gates or Greece or somewhere completely out of the ballpark here. I mean, this is 2 city blocks. It's a hair salon, which was the more unique identifying feature. And so even if counsel had brought it up at the hearing, it would have made no difference, and he can't be considered ineffective for making an argument that has little to no chance of success. And with respect to the Molyneux issue, it's our position that if these are not considered even to be acts, Molyneux wouldn't bar the admission of the future robbery plan. But it's our position that it was admissible under Molyneux to explain the basis of Ms. Schlafer's knowledge.
In your view, it's a bad act. It qualifies under Molyneux, not as a crime, but as a, usually we talk about past crimes and bad acts in Molyneux. This is, well, I guess it's a bad act to plan a crime in the future. Is that what you're saying?
Yeah, I think it would qualify as kind of a conspiracy solicitation type crime. There could have been criminal liability for soliciting aid in committing a robbery.
But if it didn't constitute Molyneux evidence, then as Justice Curran said, its admissibility turns on relevance.
Yes.
So, and how would you say it's relevant here?
It's my position that it's relevant to explain why defendant confessed committing the robbery to Ms. Schlafer. It makes much more sense that he would confess that I committed this robbery that could potentially expose me to a significant prison term if he's soliciting her aid and there's some reason for it. Otherwise, if he made some out of the blue confession, her her account of it becomes a lot less compelling, and it doesn't really make sense as to why he would randomly confess to committing a felony to her.
It shows if he's counting on her to plan things out, then it makes it more likely that jury believe that he confided in her to a felony.
Yes, and it explains, the basis of her knowledge as to why she would know this. It also there is some sort of conspiracy here, I guess, in theory too, of he might think that, okay, she's in on the plan now as well, so she's not going to, go to the police, which she in fact did. And unless there are any further questions, I'll rely on our brief.
Thank you. Case number 356, People versus Bruce Smith.
Morning, may it please the court. I'm Tanya Plank for Bruce Smith. So none of the testimony here about Mr. Smith being on probation was necessary to understanding the people's case or was inextricably interwoven with admissible evidence. The jury really only needed to know that he was arrested. They didn't need to elicit testimony that he was arrested by the probation officer, that the arresting officer recovered the key to the safe from him, but they didn't need to know that the arresting officer was his probation officer and that the probation officer recovered the key. And the jury just needed to know that the police had a search warrant and searched his apartment. They didn't need to know all of this about the probation officer told them where to search. The probation officer led them. I mean, they didn't need to know any of that. It could have easily not come out. And they needed to know that the police waited until he was gone before executing the search warrant, but they didn't need to know all of the testimony about Officer Root telling the other officers that he was gone,
Well,
that he was in his
your
probation
client,
office.
When he took the stand, all this came out. He testified, but
Right.
your point, I guess, is that he would not have taken the
Right.
stand if the
Right,
jury
I
hadn't
mean-
known he was on, it was probation for a misdemeanor.
Right,
Not the most prejudicial evidence
right.
ever.
But I would argue that what really was prejudicial was when the videotape was played and it came out that he was on probation for the possession of a gun, which is exactly what he was on trial for here.
Counselor, that strikes me as your key point.
Sorry.
That strikes me as your key point.
Yes.
The fact that it came out that he was convicted
Yes.
of this specific crime.
Yes.
And if I understand it correctly, is it undisputed from your perspective that the people violated the court's pretrial or, earlier ruling?
Yes, the court's earlier ruling, the Sandoval ruling, the court said that it was not supposed that would be precluded because it was unduly prejudicial.
So the court basically at that point has two choices, right? Start over, mistrial,
Right,
or do a curative instruction.
right,
And the court did a curative instruction.
right, yes.
Did the defense counsel at trial object to that curative instruction?
I believe he did. He took an exception and said he did think that it was unduly prejudicial and the curative instruction was better than nothing, but it wasn't going to cure what had happened. The jurors couldn't unhear that. So,
So I don't
and
want
I
to
argued
steal
that
your
as well.
thunder, but it sounds like that's the critical issue we should be focusing on.
Right, I believe so, yes. Yes, I believe the court should have declared a mistrial at that point. It was only the first witness. They were into the first witness's testimony. It wasn't very far into the trial. And the prosecutor basically just said, he said it was inadvertent. He didn't mean to do that. And the fact that it was unintentional it doesn't make it not prejudicial. So yes, that was the worst thing that happened here. And a mistrial should have been declared. And again, we don't know whether he would have taken the stand and testified on his own behalf.
If he didn't,
this didn't come out.
It seemed like he had to have some explanation of why a
Right.
gun was found in his safe that he had a key for in his room, and the bullets and the holster were all in his bedroom. If he doesn't take the stand, he seems like he's going down pretty quickly.
Well, he had said in the interrogation video that he was taking responsibility to protect his wife. And everything that was in that safe belonged to her. It didn't belong, nothing in the safe belonged to him. Other people shared that apartment, several other people. His brother-in-law shared the dresser that the ammunition was found in. So there was a lot of, and I mean, the jury did have problems with this. They did ask for testimony to be reread, and then they acquitted him of one of the counts. So, so I believe there was enough to acquit him. I mean, the evidence wasn't overwhelming if he wouldn't have testified.
We'll take a good long look at that mistrial issue.
Okay, great, thanks. If
Thank you.
if there are no further questions, I'll rest on my brief.
Thank you,
Okay,
Councilman.
thanks.
Good morning, Amy Lowensack again on behalf of the people. I'll get straight to the mistrial issue and rely on my brief with respect to the Molyneux issue.
Before you do, this case could have been tried by the people without any reference whatsoever as to the status of being on probation, correct?
It could have, but I still believe that the probation references were relevant to explaining certain parts of the people's case, specifically the fact that the probation officer had knowledge that this was defendant's bedroom, and that's where the gun was found, and explains his possession of it. So it goes towards that and establishing his control over the area where the gun was actually found.
And if it weren't, the evidence of probation hadn't been admitted, is there a danger the jury may have wondered why the police entered his house without a warrant, just started rummaging around? Wouldn't that perhaps have raised some questions in jurors' minds?
I completely agree, and it also may have given the impression, because the police said they waited until he left, that he was being surveilled in some way, and there would have been question about that. And also, I believe the probation officer came, when defendant was at probation waiting for his meeting, I think the probation officer came in and almost immediately searched him and found the key to the safe, and that would have raised some flags with the jury too as well. But with respect to the mistrial, the nature of the underlying charge was not supposed to come out, so it was error for it not to be redacted from the video. However, the court's decision with respect to the mistrial, the court's granted a great deal of discretion in fashioning the appropriate remedy here. And the court was the one that was able to observe the jurors and see their reaction to this relatively fleeting reference. It wasn't like they discussed at length the type of gun that was found or anything. It was a quick reference to, you were on probation for a gun or something, and then the court issued the curative instruction. The court...
Counsel, I don't have it at my fingertips. Generally speaking, to your recollection, what was the curative instruction by the court? Can you recall it?
I honestly cannot recall it
It's not supposed to be a
verbatim.
memory test, I just need
Yep.
that.
Yeah, I think it was, I asked you, I'm striking that testimony, I asked you, or striking that evidence, I asked you not to consider it in your verdict, but look, those types of instructions, we have body of law that says we presume that jurors follow court instructions.
Yes.
There are some that I think we all can agree it's not reasonable to expect that they would. You can't unring a bell, is the old saying, and you hear something like that, I'm not convinced the jurors are going to segregate that in the jury room. Say, he had a gun, but let's not consider that. I'm not sure how realistic that type of instruction is.
I do agree that there are some situations where the bell has been rung so loudly that the jury can't, there are situations where the jury can't unhear that. However, I think in this particular situation, it was a very fleeting reference to the gun. And also, looking at the entire case that the people put on, the gun was found in defendant's dresser. He had the key to the safe on his person when he was searched, and also he confessed to having the gun and knew exactly what it looked like. I think the confession is far more compelling testimony, and the fact that it was found in his safe and everything. So I think that the strength of the case really, shows that this one minor reference did not unduly sway the jury
Well,
here.
I just found it, by the way.
Oh.
And the court told the jury, please, in the strongest terms possible, I ask you to disregard both I'm adding emphasis where I shouldn't be, to disregard both the reference to probation and, even more importantly, the reference to a gun. Draw no unfavorable inference against the defendant, as it has no bearing on this case whatsoever. It is not proof in this case. It is not proof of any disposition to commit the crime in this case. So I think we have to look at that instruction to see whether or not, assuming the jury followed it,
Yeah.
it cured the prejudice created by the people's violation of the court's order, correct?
Correct, and it was a very strong reprimand to not consider that. Also, the jury was instructed with respect to the probation. I believe it was before any testimony was, given in this case and in its final instructions. And also, just respect to the any objection to the curative. I believe that defense counsel objected to the court not having granted his mistrial motion, but I do not believe there was any objection to the content of the curative instruction itself. And unless there are any further questions, I'll rely on my brief.
Thank you. Case 357, People versus Stanley Hinson.
Okay, may it please the court, I'm Tanya Plank for Stanley Hinson. Briefly, I'll address the waiver issue. Overall, we submit that the waiver is invalid. The court's oral colloquy told Mr. Hinson he was waiving any and all rights to appeal from the judgment of conviction herein, including any pretrial rulings. He never told Mr. Hinson any claims survived the
Counselor,
waiver.
You know,
So,
we have a lot of these types of
right,
cases.
I know, and I think this
Ever
exact.
since People v. Thomas, right?
Right, so.
It
right.
looks to me like the written waiver appeal tracks the model colloquy. Do you agree with that?
Yes, this one does track the model colloquy.
So when the court says, hey, I want you to look at this, and that's not what it said, but if the court says, hey, I want you to look at this written waiver, the
Right.
court did enough on the written waiver to say, yes, you've read it and you've signed it in the presence of the court. So the written waiver we can consider, correct?
Right.
All right. And the written waiver tracks the model colloquy. Doesn't that cure any of the defects in the court's oral colloquy?
Well-
And if it doesn't, tell me which case says that.
I believe there hasn't been any case law saying exactly that. I believe here, I mean, this is a teenage defendant. He has very little experience with the criminal law. He undoubtedly would have had a much easier time understanding what the judge said to him than a form that was probably complicated to him. And this is the last thing he heard. I mean, the judge spoke after he signed the waiver, so I would argue that the colloquy is really most important, especially for a young person who doesn't have very much experience with the law.
Right, so the question is, and I looked this up, because look, we have, if it were just an oral colloquy, I agree with you, it's invalid under Thomas, it's overbroad.
Right,
We have a good written waiver, as you acknowledge.
right.
So what does the case law say? In Thomas, I believe there's some discussion that a proper written waiver could cure defects in the oral colloquy in certain situations.
In certain situations,
Is this one of those? And do you have cases that, there's got to be cases similar to this. We have plenty of the opposite.
Right.
You have a good oral colloquy now. They're reading from the
right,
PGI model colloquy. They still
Right.
have bad written waivers. So what do we do with those? This is the opposite.
right.
Do you have case law that,
I don't
It
have
deals
that
with
case
this.
law with me right now, but I don't believe there's case law that specifically addresses this specific issue where the oral colloquy is very wrong. And the oral colloquy is really wrong here. I believe in Thomas, I'll have to go back and look, but I believe there was a little bit, the oral colloquy didn't completely say in that case that there were no rights that survived.
Counsel, just a curiosity on my part. In these cases, do you take the judge's name, put in Westlaw, and do waiver/same sentence appeal?
I haven't actually done that, but I didn't think to do that, but that probably,
that's what we do.
right. I haven't thought to do that, but.
All right, so we got to look at that.
Right.
And you say you want to submit some case law that may not be in your brief in a post-argument submission? Is that what you're saying?
Sure,
Yeah.
sure, I will do
And then
that.
if we get to that, we can't get to the merits of your issue on the YO until we get past the waiver. So we have a little
Right.
work to do there. Do you want to, anything further on the waiver before you address the merits?
The waiver, well, I know this court has had the exact same, very, very similar circumstances with the waiver and just issued an opinion on the substantive issue anyway, and just said, assuming arguendo,
Right,
the
but we
waiver's
do that
valid.
if we reject the substantive claim. We can't do that if we,
Right.
like, I personally, just speaking for myself, I think you raise a legitimate issue on the merits on the YO. He's
Okay.
already done his 2 years. He's a kid. All we're talking about now is he going to run around the rest of his life with a felony on his record that's going to be a handicap for the rest of his life?
A violent felony,
Again, he's been punished. He did his 2 years.
right,
So I don't think it's a frivolous contention.
right.
When we do assuming arguendo, the waiver's invalid, we say, we reject it. We don't
Oh, I
say
see,
assuming
right.
arguendo and then we grant the
Right.
relief, because we can't do that.
Right, okay. Okay, I see. So if, yes, I would like to submit a post-argument submission then on the waiver and look into the case law further, although yes, and write about the case law. Do you want me to,
If you want
Talk
to
about the
briefly
youthful
address,
offender.
does he, what was his record before this?
Before this, he
Before-
only had one prior misdemeanor conviction for petty larceny.
Right, now, they did give him an opportunity to earn YO. They put him on
Yes.
interim probation. That didn't work out for
No.
him. Did he pick up any, did he have any new convictions since then? 'Cause look, if he's, I couldn't check, I forgot to look, but if he's a convicted felon now on something else, well, this is all,
He did,
Irrelevant.
well, during the interim probation, he did get another, he did have a charge for unauthorized use of a vehicle, so
okay.
misdemeanor
probably
nonviolent. yes.
Misdemeanor.
Right.
He has no felony conviction as we speak today?
No, he does not. No felony
Was he
conviction.
the driver or the passenger in the UUV?
I'm sorry, I don't know about that case. It wasn't on the record, so it wasn't developed on the record. It was just mentioned by the judge, but I can look that up and try and find out more about that case, too.
All right, well, I think we have the gist of your argument, so thank you very much.
Okay, thank you.
Lisa Gray, on behalf of the people, good morning, Your Honors. With respect to the waiver of appeal, as the court has noted, the written waiver of appeal closely tracks the model colloquy. Admittedly, the court's comments to Mr. Hinson at the time of the waiver of appeal were somewhat overbroad in terms of
Would you
referencing
agree
any
that
and
if
all.
that's all we have, Ms. Gray, if all we have is the oral, you would expect us to find it to be invalid?
Putting aside the written waiver of appeal completely, I would submit that, yes, the court's colloquy was overbroad.
You know, I'm going to pin you down because sometimes your office does concede. Would you concede that here? Not that it's terribly relevant given the written, but it's given the breadth of the way the court described the waiver.
Written waiver aside, I do believe that the court's colloquy was overbroad. But I believe that this is one of those particular cases where the written waiver of appeal was, pretty rock solid. And, Mr. Hinson was 18 years old. He wasn't a young teenager. He's an older teenager when this occurred. He also was represented by a very experienced attorney who was a former assistant district attorney. So, despite some of those comments made by the court at the time the waiver of appeal was executed, I believe the written waiver of appeal, together with Mr. Hinson's age, his attorney at that time, would certainly work in the favor of the court finding that this particular waiver of appeal was valid and
I don't
would
know,
bar the substantive claim.
I don't know what we've done in the other case, we have so many of these, Justice Kern pointed out, and I'm sure the other departments do as well, but on a clean slate, it would just seem to me that if the defendant signs a written waiver of appeal, and then he's before the judge, and the last thing he hears is the judge in robes saying, you give up any and all rights to appeal, which is invalid under Thomas. What the court is telling the guy immediately before he waives should trump whatever he signed there, and may or may not have read. Here, there was no questioning about, did you read the waiver? It was, I'm holding up the written waiver, have you reviewed the waiver form with the attorney? Yes. There was no exploration of any differences between what's in the written waiver and what the court had said about you're giving up all your rights. So, I don't know, that's what counsel argues, is that it should be the last thing that said trumps. I don't think that's supported by any case law. So you're free to submit post-argument submissions as well on that.
Yes, Your Honor, thank you. Would you at this point like me to address the YO issue briefly then? I think declining the request for the YO adjudication was certainly an appropriate exercise of the court's discretion. Again, Mr. Hinson was 18 years old at the time this particular crime was committed. And, in appellant's brief, there is some mention that, sure, there was no allegation of a weapon, there was no allegation of any sort of physical injury that occurred during these events. But putting aside those types of particularly violent crimes, this was a home invasion. Mr. Hinson, together with two other people, entered into somebody's home at the early morning
They stole
hours.
like a PlayStation or something. They
And
stole a video
stole
game.
gaming consoles and PlayStations.
And didn't do, well, yeah, that's obviously a serious crime.
It's particularly egregious,
And
given
I would just say this, though, the issue isn't simply, did Justice Sinclair abuse her discretion to deny? Because I would say the answer to that is no, for the reasons you say. But we have our own independent And the question is, should we exercise our own independent discretion, even absent an abuse by Justice Sinclair? But, so it was a home invasion. He was given an opportunity. Justice Sinclair gave him fair
certainly
opportunity
was.
to earn the YO with probation, and he fumbled the ball.
I mean, not only did he fumble the ball, he struggled to comply. He was spotty with check-in. The pettit larceny conviction the previous pettit larceny conviction was reduced from a robbery in the second degree, which also satisfied a grand larceny in the fourth degree. So Mr. Hinson was not a novice to the criminal justice system by any means. And Justice Ogden, to your question, as I was sort of thinking about it when you're asking about the unauthorized use, as Ms. Plank indicated, it wasn't really developed on the record. It was a reference to this new charge of unauthorized use, but I can tell you, speaking from experience, generally when somebody's charged with unauthorized use, it's because they're a passenger. Generally, depending on the circumstances, if it was a driver, it might be a grand larceny charge. So take that for what it's worth, but.
Was it grand larceny as well? So that's which would have raised it from the misdemeanor to the felony. So I just didn't know.
Exactly. So, I mean, again, Justice Sinclair had the opportunity to kind of just track Mr. Hinson on this year of interim probation and see how he was doing. And I think that really speaks to his attitudes towards society, his respect for the law, things of that nature. So, Justice Sinclair exercised her discretion. I would urge this court, if you reach this issue, exercise the same discretion and agree with Justice Sinclair below that it was an appropriate denial for this youthful offender adjudication.
Counsel, I have a question. On the robbery that was pled down to petty larceny that he received YO for, you said there was a grand larceny.
I'm sorry, I don't mean to interrupt, but he did not receive YO. It was a pettit larceny conviction.
Oh, he didn't receive YO on that?
I believe
He did.
I think he did.
I'm sorry, you're right, sorry,
He
Judge.
did
Yes,
receive
or
YO
Justice,
on
yes,
that.
you're right.
But was the grand larceny, was that the same crime, or were those two separate crimes?
Two separate charges.
So two separate charges, 2 different days, received one petty larceny YO adjudication.
Well, I can't speak to whether or not the robbery in the second degree and the grand larceny in the fourth degree were in 2 separate days, but they are 2 separate charges. The robbery in the second degree was reduced to the pettit larceny, which he pled guilty to, and that plea satisfied the grand larceny.
But it could have all been from one criminal transaction.
It could have been all from one criminal transaction, I just don't
That's
know.
what my question was.
Okay,
All right, thank you, counsel.
thank you.
359 is People versus Gregory Jesmer. Good morning.
Morning, Your Honors. Kathy Reardon for Appellant Gregory Jesmer. I'd like to focus on points 4 and 2, and I'll rest on my brief for the remainder unless, sorry, if the court has any questions. We've addressed in point 4 that we believe the search and seizure of Mr. Jesmer and his property, the bag, was unlawful, and thus all the evidence obtained as a result should have been suppressed as fruit of the poisonous tree.
So the evidence that should be suppressed from the backpack was the blue latex gloves and the beer canisters that were found in there?
There was also a receipt that was found in there that went back to South Avenue, which led to the police to go and look at the surveillance video.
Right. So
and
do
everything.
would that result in the suppression of the purse that was found at the store? Because that, or would it just, is it just the receipt itself or evidence that flowed from the receipt?
Well, I think it would be everything that flows from the receipt, and they also found her key to her apartment, his keys, and so I think that kind of
Well,
opened the door to everything else, to
That was
their
on his person,
investigation.
right? When he was at jail, he emptied his pockets, and that's when the keys came out.
There, in the video, when he's first searched by Officer Perry, and he's got his body-worn camera, and I would ask the court to go back and review the video. It looks like he did not actually do a frisk. He actually immediately started searching his pockets. He took out the pocket knife, but it also appears that he took out some other things, including cigarettes, which become important later on. And also, we believe that the key, her key, was also in his pockets. And there was even mentioned by defense counsel that we can't really tell, because it's kind of in and out of the body-worn camera, actually what was taken out when they did the initial search of
Right, well,
him.
on the video during the interrogation, it looks like he empties his pocket. He still has those items on him. He has that little clock, the
clock.
alarm clock.
Correct.
He has keys to her apartment in his pocket.
He does.
He has the cigarettes. So if there was a frisk of some sort, nothing was seized from him at that time when he got into the car. He still had them in his pocket when he arrived at the police station.
Correct. I guess the point before that actually is, we don't believe that the frisk or the search ever should have happened in the first place, because I don't believe that there was any criminality that allowed the Officer Perry, to get to that point. He approaches him, he sees what he's doing.
Urinating, that's a violation of the penal law, right? Urinate in public?
It is, but that wasn't the basis for the search or what we're alleging is a search.
Right.
They based it upon the fact that they believe that there was an Ewok here. And we'd submit that what the officer observed didn't, or what he was told, never rose to that level. So there was no level of criminality. He certainly had a right to go and engage him and ask about a situation. But I don't even think that it got to a level 2. And if that was the case, he would have walked away and none of that ever would have occurred.
When did they find out about the petty larceny warrant from Henrietta?
Not until he was in the car. Not until
So
he
you're
had already.
saying after Pat Frisk?
Correct. Not until he was in custody.
I'm
Then
sure
enough-
Mr. McCarthy's going to say, well, they were investigating. This didn't have to be a full-blown arrest. They had a level 3. They had a woman who just called the police, said this guy with a blue backpack, matched the description, had been trying to lure this woman into his apartment by offering her large sums of money. Wouldn't that warrant an investigatory stop? And they got to search him before they put him in the car, just ask him some questions.
Well, again,
That's what No.
I think they had the right to go ahead and engage him in a conversation. What happened with this young woman? He explained, he said, I'm doing random acts of kindness. I'm a vet. I offered her some money because
Well,
she.
first he said, what girl? Like, he started
did.
lying. His immediate instinct was just start lying.
He did.
And then he got caught on his lies. And then he came up, he said, well, I was just offering her a small amount of money. Just because he felt bad for her, even though he's behind on his rent, has no job, and he's broke himself, but.
Okay, but nobody knew that.
Right, correct. But so he, at that point, the officer should have said, okay, that all checks out, that makes sense, you can go on your way?
Well, I think they had the right to question him initially,
Right.
but to within probably seconds, to turn him around and start digging into his pockets and searching him based upon what was a really questionable, and we didn't think, was an Ewok. I think he jumped to level 3, and at that point, I think that, as a result, everything else should have fallen from that. And when they detained him, look, they have the right to detain if they're going to do some kind of show-up or something along those lines. It was never mentioned, they never did a show-up. The girl was apparently still across the street, but they never bothered to do that. They put him in the car and went from there. At that point, that's when they found out about the warrant.
Yeah, so this ties into your point on the sufficiency of the evidence on the endangering charge, is that does it,
Correct.
if the defendant goes up to a young girl and offers money to come back to an apartment, and she says no, and then he ups the offer, keeps upping the offer to $1,000, she says no, a woman driving by calls the police, intervenes, and the guy, well, is that endangering the welfare of a child? I agree with that, it's not, it's close. Now, if he had gone to fruition, what he allegedly intended, then we get there, but he was prevented from doing so. So is that alone, offering money to a child to come to your apartment unsuccessfully, is that endangering the welfare of a child?
I would submit that it isn't, and I can kind of throw the weight of the evidence in there as well, because his testimony was that never happened. I got off the bus, and again, they got off at the same bus stop because they both lived in the same apartment, and they were walking in that direction to go to that apartment. He says, I heard her say something about losing a wallet. I said, I went up to her and said, I'm a returning vet, and I'm doing random acts of kindness. She confirmed that. She agreed that that's what he said. He says, I offered her $10 to $20 that I had on me, and they... Go ahead, I'm sorry.
Yeah, I don't think the weight is strong. I watched his entire video, and I think jury could, there's almost no way they would believe much of what he would have to say, but I think your sufficiency is legitimate contention.
If the court has no further questions, I'll rest on my brief.
Thank you.
Good morning. Marty McCarthy for the people. Starting with the suppression issue. The court below had found, in addition to the fact that the officer had the ability to investigate the endangering charge, that the defendant was engaged in additional criminality, which is the urinating public exposing person. And in fact, he actually confirmed, the officer confirmed that crime in the sense of he asked the people, and as you could see on the video, he asked the people that were nearby, hey, do you know what he was doing in there? And they say, yeah, we know what he was doing in there. We could see him.
So that's it's not a crime, but it's a violation?
It's a violation that occurred in his presence,
Right.
which means he could have arrested him for that. And I believe, when you read the court's decision, the court did take that into consideration in determining the propriety of the officer's actions.
So even without reasonable suspicion of endangering, the urination justifies putting him in the, frisking him, putting him in the car?
Now, when you say, even without the endangering, the way I'm hearing it and the way the discussion went with the legal sufficiency is that you don't feel that there was sufficient evidence to establish endangering, but there
No,
certainly
I was just saying, I was merely saying that it's not a frivolous contention.
Correct.
I think that the evidence on the murder is in a whole nother stratosphere.
It's a whole other stratosphere. I will totally agree with you with that. But you said it was close, and I guess I would agree with you, but that doesn't change the fact, and I will seize on what you had said, it certainly sounds like an attempt, which is also a misdemeanor, it'd be a big misdemeanor in that scenario. He was attempting to endanger the welfare of a child, still can result in an arrest based on the fact that it's a misdemeanor. Part of the reason why there was no show up is they didn't need to be a show up in this scenario, because once they confirmed he had a warrant, they could do, as you could see what happens, they do the administration of a photo array as a result. So they didn't have to clear up, hey, is this the right guy or not, which is typically the rationale for a show up. They didn't need to do the show up for that reason.
Because he admitted that he had this interaction with her.
Yeah. So in that sense, there was no urgency to do the show up, and show ups are generally disfavored anyway. So they didn't do a show up, but that's why they didn't do a show up. It wasn't because the officer didn't believe her, that there was
What's your view of the timing of what evidence was seized from the backpack? Was it just the blue latex gloves and beer, or was the receipt in there?
I thought the receipt was in his pocket.
That was my understanding.
That's where I
And that was all emptied onto the table in the interrogation room.
correct. What was in the backpack was his beer and the
Latex.
blue latex gloves.
Neither of which was admitted into evidence at trial, right?
Not that, the beer certainly wasn't, and I don't believe, actually, I believe the latex
But
gloves
it
may
wasn't
have been.
incriminating in any way. I mean, there's no allegation that they were used in any crime.
No, but I do believe actually that the blue latex gloves did come in. But when you consider where the bag was, the bag, at the time the officer approaches him, the bag is actually to his side. He doesn't have the bag on him at that point. So the
Why
officer.
search the bag? What's the justification for searching the bag?
At the time, he didn't search it. He did a sort of a cursory view of it because he was going to put the bag in his car. He wanted to make sure there was nothing unsafe in the bag that needed to be secured. So he doesn't seize anything at that time either. That's the other thing to remember.
He does open and look in.
He opened, make sure nothing dangerous, closes it up. Because in his mind, at the time, you can tell, despite the fact that what's going on just maybe yards away, which was the murder investigation, in Officer Perry's mind, that this is simply a misdemeanor investigation he's engaged in. He's not looking for evidence of a murder, if you will. So he did a cursory view of the bag, didn't seize anything at that time, closed the bag up, put the bag in the front seat of his car, took the knife out of his pocket, which certainly was a dangerous instrument, shouldn't have had in the back seat of the car, but he didn't take any, as you pointed out, he didn't take anything else from him at that time.
So the bag, looking into the bag was to see if there's something that's dangerous in there, but the defendant didn't have access to it anymore, so like, what difference does it make if there's a gun or a knife in there? He's not gonna not going to be used on anyone at that point. So I guess what the defendant's saying is there's no need to be looking in there, and you need to get a warrant. That's, I think, their point.
And I take that point. The officer did explain why he did what he did, but ultimately the evidentiary value of what was in that bag was minimal anyway.
Right.
So even if you were to find it, that.
It would be harmless on the murder for sure.
Certainly harmless on the murder. And in terms of the endangering charge, that's its own cup of tea, if you will. But ultimately, again, when you look at seizure, nothing was seized until he got to the police station because he was under arrest at that point for the bench warrant. So at that point, yeah, they definitely did have the ability to seize the property as a search incident to arrest, which was, he was under arrest for the bench warrant at that point. And at that point, they did seize the property because until they confirmed the bench warrant, they hadn't seized the property other than the knife that was in his pocket. And turning to the sufficiency, you're right. This is a sort of an unusual endangering the welfare of a child. But when you consider what was going on, he was trying to get this young girl to go back to his apartment his building where he had committed a murder. To me, offering a young girl for money to go back to your apartment is actually endangering the welfare of a child. And even if you don't say he wasn't successful in getting you back to your apartment, it was certainly enough for an attempted endangering the welfare of a child. If there are no questions about the sufficiency or weight on murder charge, I'd rest on my brief.
Thank you.
Thank you.
359 is Solomon versus Whitley. The appellant has submitted. We have the AFC attorney for the child virtually. Ms. Gray, good morning.
Good morning, Your Honors. I represent young Tina Coley. She recently turned 9 years old. She's continuing to live with her maternal grandmother. She's doing well in school. She's engaged in extracurricular activities such as dancing and wants to do gymnastics. She's very happy with her placement. She's also very fearful of visiting with her father. So unless the court has any questions about my submission, I would rest on my brief.
Thank you, Ms. Gray.
Thank you.
Brown versus Over the Top Roofing LLC is case 361. Good morning, Counselor.
Justices. I believe my opponent is.
Yes, there's a submission for the respondent.
Okay. I will be brief then, otherwise rest on my papers, Your Honors. The issue below was that the Supreme Court, I believe, misapprehended that there was a question of fact with respect to any alleged leak. Plaintiffs have admitted that there was not. There is no causal connection. There's no proof of any leak. They changed their argument to an implied promise of working-related conduct based upon the aesthetics of the shingling and the siding, which is all laid out in the papers. You have a lack of connection to any objective damages here, and they're without any causal connection. They have no claim. So that's my argument. Are there any questions?
Thank you very much, Counselor, for coming in. Appreciate it.
Thank you, Your Honor.
362 is Courthouse versus Dykers Incorporated. 362.
Good morning, Your Honors.
morning.
Kevin Loftus for the defendant, Dakers, Inc. This is a pretty straightforward case. Facts are pretty much undisputed. Plaintiff simply was not looking down when she descended the stair. We understand that usually just goes to the comparative negligence issue, but in cases where the record shows that it's not in an inherently dangerous area, courses can dismiss them as a matter of law.
The photograph on page 178, plaintiff seems to be relying on that a lot.
Yes.
You got to admit, from that angle, you can't tell that there's any step downs. From that one particular angle, I agree with you. You're looking at it, it seems to be more of a danger as you're going down than when you're coming toward it, but
I would agree with you.
that,
The only
on 178, looks like one continuous level.
Right, and then the only thing I would point out, and we point this out in our brief, is that is taken from a different angle. That is taken by the plaintiff's husband.
Right.
But the angle where she comes down is straightforward. You're looking at an angle where, he probably did his best to, make that as confusing as possible. But I think if you look at the record and you look at the other photographs, and the Judge Rose, the underlining court, said this is a normal step. It's an ordinary step. And that's what I think I want to focus in on, especially, in the brief, both the open and obvious condition as well as the not inherently dangerous.
The open and obvious only gets you so far with respect to duty to warn. That's not going to take care of the reasonably safe condition issue.
Right, but if you tack on the inherently dangerous,
Where does inherently dangerous come into this equation? As I understand, the PJI has the verdict sheet, and it tracks it as, the first question, did that condition exist? Second question is, was that condition, unreasonably safe, not reasonably safe condition? Obviously, you forgot the wording, but I don't know where inherently dangerous comes into this calculation under the law.
Well, the inherently dangerous, I think, comes into play when you start dealing with the code violations, these alleged code violations. Do these alleged code violations make this stare any more unreasonable than a normal stare? And I would relate this case to the Galasso case. There's no difference between this plaintiff not looking down and falling down than the plaintiff in Galasso who admitted that she was walking backwards down a ramp. Now, both plaintiffs in both of those cases, the plaintiff here and the plaintiff in Galasso, have now tried after the fact to try to craft an argument that somehow there was negligent and there was a defective condition. The court in Galasso, 25 years ago, said whatever defective conditions might have existed with this particular ramp had nothing to do with the actual fall. It was her fault. You looked at, and again, I know that goes to comparative, but in these instances where there is nothing inherently dangerous or there's no unreasonable condition, this was a normal step. The ramp in Galasso was a normal ramp.
Mr. Loftus, that's why I'm not so sure the cases that use inherently dangerous are entirely accurate, because the question is whether or not this particular condition was in a reasonably safe condition. If the jury says no to that, then you keep going to comparative fault on the causation issue, or the causation comparative fault.
Right.
And you're sort of respectfully sort of bouncing around among those various levels. And I can't get to the causation until first you assume arguendo, in effect, that there was an unreasonably, a dangerous condition. So where are you on this? Are you arguing that the jury should, that as a matter of law, this was not a dangerous condition?
Yes.
Okay, and
Yes.
so you think under your argument, we can stop there in the analysis?
Yes, yeah.
Okay.
There is a series of cases, and I understand, and that was the biggest issue that we had to deal with in the brief, that, usually this just goes to comparative. But there is a line of cases where, in addition to being open and obvious, it's a reasonable condition. It's not an unreasonable condition.
And for you to win on this appeal at that level, I'm not suggesting that you're waiving your other arguments.
Nope.
Is that we would have to say, as a matter of law, this was not a defective condition.
I agree with that statement, yes, Your Honor.
Okay. Now, what about the plaintiff's argument? And it's funny, we were just doing the PJI work where we stuffed cases.
Yes.
And I'd forgotten that this was in this case, but the concept of optical confusion, and I know the plaintiff has cited that there. We also have a case called McFeely that talks about optical confusion. We only use that expression twice in the Fourth Department that I could find.
Okay.
So isn't this, given the picture that Justice Lindley referred to, isn't this at least a question of fact as to whether or not this condition becomes dangerous by virtue of optical confusion?
The only thing I would point out to that, and I understand the argument, yes, and it's a tough argument for me to sit here and say, there's not going to be a question of fact, but the angle of that photograph, I would just point out again, that was taken from a different angle. And then the optical confusion issue, our only argument, and I believe it's a very strong argument, is that she didn't look down. She can't, I don't know how someone can claim that's an optical confusion when she doesn't even observe the condition.
Well, the wood looks, it's the same color, same type of wood.
Right.
Everything go in the same directions. And
Go in the same direction in that angle that he
Yeah.
takes the picture in, yes.
And there's no, usually you see on these step down, we have a lot of step down cases.
Yeah.
There's some that's been cited here, others that haven't, but usually in bars or restaurants or business establishments, there's one level to another, and sometimes there's a yellow tape, sometimes there's a watch your step. We didn't have any of that here. But it does seem to be more of the illusion as you're going down the steps than when you're approaching them. And as Justice Curran said, the Court of Appeals has said whether a dangerous or defective condition exists depends on the particular facts and circumstances of each case and is generally a question of fact for the jury. So that's the general rule. You're asking us to go outside the general rule based on what?
Based on, again, not just that picture, but there was a number of pictures submitted. The testimony, the lighting that was available, this is an exterior stair, there was no lighting conditions. There were visual cues, despite what I think the plaintiff argues. There was a railing, there were pillars. I just don't see this as an inherently dangerous or an unreasonable condition, and that would be our argument.
And Mr. Loftus, just to bring you back to what I thought was your secondary argument, and correct me if I'm wrong.
Yes.
But you just argued a few moments ago that she missed the step, she wasn't looking. So really, you would have to make that argument conceptually, this is the way I have it in my brain, you would have to answer question 1 against you. That is, there was a defective condition, and only then do you consider whether or not that was a proximate cause. And you first have to look at whether or not that was a proximate cause of her fall. If you found out that defective condition was not, I mean, I don't know how you get to the analysis of she was at fault in this case. I mean, how do you get there?
Again, I just keep going back to, and I think the Galasso case is probably the case that is, she was walking backwards and she was in a hurry, and after the fact, they get an expert to say, well, this ramp was sloped, it was against the code. Then the Fourth Department came back and says, no, whether or not the ramp was a couple inches off, they had nothing to do with the accident. She was walking backwards, she was in a hurry. There's not much a difference between that plaintiff and the plaintiff now, who's on her phone, walking out to beautiful scenery, looking to take a picture, and just misses the step.
Yeah, that scenery, by the way, that could be irrelevant. I mean, it's a gorgeous backdrop with the lake, and you can see how somebody's attention would be focused on the scenery and not where you're going. But I read your brief to argue in the alternative. Look, it's not a defective condition inherently or otherwise. It's not a dangerous condition.
That's correct.
In the alternative, even if it was her own fault because she wasn't looking.
That's our position, yes. If anyone else has any questions, I'll just rest on my brief.
Thank you.
Thank you.
Morning, Your Honors. John Collins for the plaintiffs. And I think that contrary to Supreme Court's determination, there is a question of fact here as to whether there was a dangerous condition. And even if there is a question of fact as to Mrs. Pertulis's comparative fault, it's certainly, she did not, by her actions, constitute the sole proximate cause of her fall.
Did you say contrary to Supreme Court's determination?
Yeah.
I thought Supreme Court ruled for your client.
Yes, I mean, yes, I misspoke.
Okay.
As the Supreme Court found,
right.
There's certainly a question of fact.
The trial court relied on Hutchinson to say whether there was a trivial defect. That doesn't seem to be the right analysis.
Well,
a trivial defect assumes there's a defect. I would think that the question is there a dangerous condition, not whether, I'm not even sure that there's usually when we do trivial defects, it's a sidewalk or something that's a little minor, just a little height. This isn't a trivial defect case, doesn't seem like. Is it dangerous to have the stairs in that manner or not?
I agree, Your Honor, that it's not a trivial defect case. I think the reason the trial court treated it and addressed it is because that is and was, the first point raised by the defendant in moving for summary judgment. And in, point 1 of our brief, I point out that, it's plaintiff's position is the trivial defect doctrine isn't even arguably applicable because, as Your Honor pointed out, it usually involves protrusions or depressions of, say, ½ inch, inch and a half, 2 inches. Here we're dealing with a change in level on this deck totaling 12 to 14 inches with a step in the middle, so it's really, you know, you could view it perhaps as a, 12 to 14 inch, change in height, or perhaps two separate 6 to 7 inch changes in height. But I don't think either one arguably gets, into the arena of trivial defect. But I think the trial court treated that issue because it was one of the two arguments that defendant raised in seeking summary judgment.
Is it, what the defendant says, which does have some compelling logic to it, is when we're talking about whether the stairs are dangerous. Nobody's ever fallen on it before. There's been that way since, 2004, whatever, how many years ago, decades ago. 600 people a day, he says, go up and down those steps. Never before has anyone fallen. Therefore, that's a pretty compelling argument that it's not a dangerous condition. She's the first one in all these years. Must have been her, not, this isn't a common problem, right?
I disagree. I think that there are many trip and fall or similar cases where there is not a long ongoing history of, individuals in the past falling. But I don't think that may raise a question of fact, something that can be argued at trial. But I don't think that it establishes as a matter of law that the condition, was reasonably safe.
If Mr. Collins, if the stairs were completely code compliant in terms of the distance between the steps, would you still have a case here?
Yes, certainly, because compliance with building code provisions is relevant to the question of whether it was reasonably safe, but not dispositive.
Understood, but what would the defective condition be if it wasn't a code violation?
I think the defective condition would still be this sense of optical confusion because...
in a way, you don't need the code violation, given the way that one picture looks. You would say that we still get to a jury on optical confusion.
I think you would, but I don't think that we should ignore the code violations. And as to that, well, first of all, on the issue of whether there was a dangerous condition, no mention was made yet of the waitress who witnessed the fall and told Mrs. Kratoulis immediately afterward, words to the effect, we knew something like this would happen. We used to have the step marked with yellow and black stripe, and it's no longer there.
Is that admissible? It sounds to be hearsay offered for the truth of the matter. Does it fit within the new CPLR definition of an employer's statement? Is that what you're...
Yes, it fits, I think, squarely within the CPLR 4549, which has been in effect for about a year and 3 months now. And
but for that new statute, this is inadmissible?
But for the new statute, that would probably be inadmissible. But the statute was designed to change and make it admissible and get away from the concept that such statements by an employee are admissible only if they're, authorized to speak on behalf of the employer. That was the whole thrust of what the legislature wanted to do in enacting 4549. So I think you've got that as an indication that, certainly, the staff there and, the employer too, one could reasonably infer, was aware that there was a condition there that had once been marked with a yellow and black stripe. And that kind of meshes with the question of code violations because our expert and architect, stated that this was subject to the 2002 code and identified a couple of provisions that were applicable here and that in his opinion, were violations and, constituted certainly a cause of this, which is the lack of what he called, quote, tread contrasting marking stripes on the stair and the lack of a handrail on each side of this long step. And he said even, one in the middle given the length of the step.
Thank you, Mr. Collins.
Thank you,
I think we understand your argument.
Oh, if I could, Your Honor. The issue that plaintiff caused this by, looking straight ahead.
Right.
I would ask the court, and this is cited in my brief, to take a look at the case of Power St. Bernadette's Church from this court in 2003, where the defendant argued, and there the plaintiff fell while stepping from a room into a hallway in a church building. Defendant argued that plaintiff was the sole proximate cause. She was, quote, looking straight ahead rather than at the ground. The court said in that case that raises most a question of comparative fact. And, realistically, people look straight ahead while walking, unless you're, say, stepping across stepping stones in a creek. It's not common to look down at your feet. You look ahead, which is the way I look when I walk up here and the way I'll look when I walk back.
Mr. Collins, just as a curiosity on my part, I'm not so sure that the sole proximate cause argument by a defendant works outside the 240 sub 1 zone. To me, it might relate only to that concept, because I think when a defendant moves on proximate cause, they have to establish that even assuming we were negligent, that negligence as assumed was not a proximate cause. They don't have to blame it all on the plaintiff. They can just have to show that their conduct was not a proximate cause. Am I close?
I think so, yes. I mean, they are essentially arguing, hey, it's plaintiff's own fault. I don't think, for the reasons Your Honor articulated, that that's a good defense here. And I think there is a question of fact as to whether there was an unreasonably unsafe condition by virtue of all the factors that were addressed.
Thank you, Mr. Collins. Case 363 is Dennis versus Cerrone. Mr. Gorski, it's the third time your office has been up here on this case.
Good morning, Your Honors. Jonathan Gorski on behalf of Plaintiff Appellant Joseph Dennis. And you are correct, Your Honor. This is the third time that this case has made it to the court. So there have been 3 separate records before the court. And although there have been 3 separate records, the relevant facts have not changed in any meaningful way.
There's only been one trial. The prior appeals, we pretty much we thought this was a triable case. This case should go to trial. So now we finally have that. So it's a little different than before. We had summary judgment motion on the first one, then we had a directed verdict on the second one, and now we have a full-blown trial with a verdict afterwards. It sounds like am I reading your brief correctly, that your challenge is, your main contention is that the court's verdict in this non-jury trial is against the weight of the evidence? Is that terminology, against the weight of the evidence? Does that accurately describe what your contention is?
Yes, Your Honor. We believe that the evidence is overwhelming, actually, in favor of plaintiff, and the verdict should be reversed and judgment should be rendered in favor of the plaintiff. There is no dispute, really, between the parties over the facts, over what Mark Cerrone, Inc. did and did not do in connection with this construction project. The central factual dispute on summary judgment at the first trial and at the second trial is whether those actions are attributable to Mark Cerrone, Inc. so as to hold Mark Cerrone, Inc. liable as a contractor under the labor law. That central factual dispute was decided for the first time at the second trial by Justice Sedita. Justice Sedita determined.
Don't lose your train of thought, but following up on the Justice Presiding's question, as I understand it, you're not arguing that there was insufficient evidence to go either way, because we kind of already rejected that in the second appeal. Again, just to emphasize, we're going to have to apply the standards pertaining to a weight of the evidence review, including deference to the court's evaluation of credibility, things of that nature. I just want to make sure that we're all on the same page, that our review here in this appeal, as you presented it to us, is the weight of the evidence standard of review.
This is a legal determination. As I have mentioned, the facts are not in dispute over what the Mark Cerrone, Inc. employees did and did not do. The question was whether those actions are attributable to Mark Cerrone, Inc. Justice Sedita decided that those actions are in fact attributable to Mark Cerrone, Inc. He stated in his decision that the actions of the Mark Cerrone, Inc. employees were undoubtedly at the behest or suggestion of Vincent Cerrone, who was surely taking advantage of his status as part owner of Mark Cerrone, Inc. With that factual dispute decided, what this case turns on is a legal determination. The legal determination is whether those actions are sufficient to hold Mark Cerrone, Inc. liable as a contractor. That's the legal determination. This court provided the legal framework to make that determination. The legal framework provided by this court in the 2021 decision is whether Mark Cerrone, Inc. had the power to enforce safety standards and choose contractors, or whether Mark Cerrone, Inc. had the power to supervise and coordinate the overall project. That's the standard. Justice Sedita applied an incorrect standard when he reviewed the evidence, when he evaluated the evidence. What Justice Sedita decided was that Mark Cerrone, Inc. did not expressly exercise direction, control, and supervision. That is not the standard.
Your argument is that it's not what you did, it's what you could have done. Is that fair to say?
It's what you did and what you could have done.
Right, and here, you say, using the correct standard, the employees from MCI who were at the work site, I think it was Mr. Fida and Mr. Johnson, those were the only two besides Mr. Cerrone, who then left and he went on vacation to Australia for a couple of weeks. But those are you're relying primarily on the actions of Johnson and Fida. Fida was a general laborer who did a lot of cleaning up, did some demolition work on the garage and all that. And Mr. Johnson, who was a site supervisor when they did road work. Am I correct that your case was rise or falls on their actions at the work site?
I would agree with that. There's a little bit more. There was a dispatcher involved, and there were also drivers that were involved. And the drivers drove material and equipment to and from the job site. With
But they wouldn't have the authority, the drivers wouldn't have been involved in supervising the work or enforcing safety rules, right?
That's correct. Who was involved in that, who had that authority, as Your Honor pointed out, was Bill Johnston.
He's the main one.
Bill Johnson is a Mark Cerrone, Inc. superintendent. And let me be clear on one thing here. Vincent Cerrone is not friends with Bill Johnston. Justice Sedita asked Bill Johnston those questions directly when he was on the stand. Are you friends? No. Do you have a personal relationship? No. So that begged the question to Justice Sedita. Well, if you don't have a personal relationship and you aren't friends, why are you doing this? What did Vincent Cerrone say? Vincent Cerrone said he was doing this as part of the company. And let's take a look at what Mr. Johnston did. Mr. Johnson reviewed the plans, he solicited bids, he recommended contractors, all of which were hired by Vincent Cerrone. He applied for and picked up the building permit. He met with all or nearly all of the contractors on site. He served as the site contact for the delivery of materials, including the lumber that was used in framing operations. He served as site contact for the contractors, including the framing contractor. He visited the site to check on the progress of the work and to make sure that the contractors were working. He discussed an architectural error in one of the drawings with the framing contractor. He resolved that discrepancy. He ordered additional lumber to make that, or to fix that mistake. After the incident, he came back to the site and investigated the injury. He investigated the injury so that he could report to Vincent Cerrone on what happened when Vincent Cerrone was in Australia. What shouldn't be lost on this court is that this was not some large municipal or commercial project. This was a very small construction project. It was a 900-foot addition on a pre-existing home. When you look at the amount of coordination, the amount of supervision, the amount of direction and control that was exercised in this case by Bill Johnston, and you compare that to the size of this project, that is incredibly overwhelming evidence of the power to supervise and coordinate this construction project.
You make a lot of good points, and that's why we thought it should go to trial. What the defendant argues is that Mr. Johnson, there were no employees who worked on this project, including plaintiff, I believe. There's nobody who testified that they thought Mr. Johnson had the ability to supervise a worker, enforce safety devices. Would you agree with that?
That's not uncommon at any construction site. If you asked a laborer or a carpenter or a framer who has responsibility, what they're going to say is, well, we listen to our employer, right? But that's not, those two things are not mutually exclusive.
Mr. Johnson testified, I didn't have authority, I didn't think I had authority to tell him what to do or to enforce safety devices. There were no workers who thought that he did either. Now, you're saying it doesn't matter, you could still prevail here. They also rely on the fact that MCI didn't do residential work. As a matter of fact, the primary owner of MCI Mr. Sharon would only own 34%. The primary owner had no idea that this work was even going on, didn't authorize it, said that Mr. Sharon was not authorized to have the business be doing this type of work. She first found out about it after your client had been injured. Is that relevant? Is that evidence on the other side? Oh, you got a lot of good evidence on your side, but can we stack that on the other side of the way?
There are a couple things there, Your Honor. First, on the testimony of Mr. Johnson, we have to look beyond his testimony. And as the old saying goes, actions speak louder than words. And it's his actions, the actions that he undertook at this project as a Mark Sharon, Inc. superintendent is what provides the requisite authority to direct and control the work. Now, moving to the owner, Stephanie Shirakos testified that she was unaware. But this was not unusual in this case for owners of Mark Sharon, Inc. to use the company for their benefit. In fact, Ms. Shirakos testified that she had work done at her house. I think a pool house was built and some other work that was built that was performed by Mark Sharon, Inc. So the fact that she was not aware of this work ongoing is not dispositive. Frankly, I'd argue that it's not even relevant here.
Were any of the contractors, including the framing contractor for whom your client worked, were any of them paid by MCI as opposed to Mr. Sharon himself?
They were all paid by, ultimately, Vincent Sharon. Now, the materials were purchased by Mark Sharon, Inc., and then Vincent Sharon paid for the materials at the end when there was a deduction from his profit sharing. Now, this arrangement is not illegal. There's nothing improper with using your construction company for this purpose, but when you use your construction company for this purpose, and your construction company has the authority to direct and control the work, there are consequences and there are requirements. The requirement is you need to comply with the law. Here, Labor Law Section 240, 241 subsection 6, and 200. Here, there was a violation of Labor Law 240 and 241 sub 6. And it's so obvious that it was not even challenged at trial. This court has the authority to stand in the shoes of the trial court. This court has the authority to render judgment as it sees fit on the facts. And the evidence here is truly overwhelming. I went through the evidence a few minutes ago that Mr. Johnson on supervision and coordination. I just want to take a second to talk about safety. When Mr. Sharon left and went to Australia, he left a list for Mr. Fida, who was the laborer. And what did that list say? The list said, keep an eye on the project, something along those lines. Keep it neat and clean. So what did Mr. Fida do? Mr. Fida went to the job site while the framing operations were ongoing. He swept up sawdust, he swept up screws, he swept up scraps. Why did he do that? To provide safe footing for the framing contractor employees.
Was he paid for all that work by MCI or by Vincent himself?
Mr. Fida was paid for that work by Mark Sharon, Inc. He submitted a time card, he was paid by that work. In addition to performing housekeeping responsibilities, he also put up barrier tape over the doorways. Why did he put up that barrier tape? To prevent framing contractor employees from falling. That's the exact hazard that we have here. We have a falling hazard, a hole in the floor that was not covered, it was not guarded, it was not otherwise barricaded. Mr. Dennis took a step back while performing interior framing operations, stepped through, fell 10 feet to the concrete floor below, was knocked unconscious. He basically died on the floor at that site, but for the heroic acts of his coworker who performed mouth-to-mouth and got him, thankfully, brought him back to consciousness so he could be mercy flighted to ECMC to be treated for his significant, serious, and life-altering injuries. This is a case where actions speak louder than words. The actions of Mr. Johnson, the actions of Mr. Fida display the requisite authority to direct and control the work under the New York State labor law. And this court should render judgment in favor of the plaintiff based upon the record at the second trial. In addition, we're asking this court to make a determination on damages. There was damages proof that was submitted that was wholly unrebutted in this case. Not only did the defendant not call witnesses, the defendant didn't even cross-examine the plaintiff's witnesses on damages. So what better case than this for the court to stand in the shoes of the trial court and not only render judgment on liability, but also render judgment on damages and end this case once and for all. Unless your honors have any further questions, I'm happy to rely on our
I
brief.
do have a question. Johnson, was he a part-time worker at the time that this went on with MCI, but then was hired full-time after this, correct?
That's correct, Your Honor. So he
Okay.
was a part-time superintendent at the time, and after this project, he was then promoted to full-time
Full-time,
status
right?
with Mark Cerrone. Yes,
Okay.
that's correct, Your Honor.
His son worked for MCI?
That is right, Your Honor. The testimony is that his son worked for Mark Cerrone, and then Mr. Johnson began working for the company on a part-time basis as a superintendent, and then after this project, became full-time.
Thank you, Mr. Gorski.
You're welcome.
May it please the court, Edward Perlman on behalf of defendant respondent Mark Cerrone. The focus of appellant's argument seems to be the conduct and activities of William Johnston. Mr. Johnston did three things. He obtained quotes from vendors only for the concrete, lumber, electrical, and roofing, not for the framing. Secondly, Mr. Johnston ordered some of the lumber that was used. And third, Mr. Johnston picked up the building permit.
Didn't he recommend some contractors as well?
Yes, he did. He recommended his cousin for the concrete. He recommended lumber prices. He recommended the electrical contractor and some of the roofing materials
Do
he
we know,
recommended.
like, the total number of contractors, how many he recommended to Vincent?
He recommended, I think, 4 out of the 10. And he had, by the way, Mr. Johnston, the evidence was clear. He had no authority to enter into contracts. He had no authority to ensure that the work was properly performed. He had no authority to recommend payments. He had no authority to schedule the work. He had no authority to make sure that the work was performed safely. He had no authority to inspect, to make sure the contractors were working. Contrary to the arguments presented by Mr. Gorski, Mr. Johnston did not appear on the site to make sure people were working. Furthermore, he didn't investigate afterwards. To focus on Shaliga, Shaliga was the site contractor for the framing. Shaliga was plaintiff's employer. And I think the proof is clear from all the Shaliga employees, Mr. Steinbroner, Mr. Cerrito, Mr. Shaliga himself, that Bill Johnson had nothing to do with this project. He didn't tell him what to do. He didn't suggest anything. He stopped by the site a couple of times. Mr. Johnson, by the way, wasn't paid by Mark Cerrone for this work. And frankly, he was working at another site for a portion of the days on the 2 days that he visited the site. Mr. Fida was just somebody who swept up and cleaned up around the site at Mr. Cerrone's request. By the way, that barrier tape, that was put up before the concrete was poured. So Mr. Cerrone himself operated the backhoe, excavated, had Mr. Fida, while there was still dirt there before the concrete was poured, had Mr. Fida put barrier tape around. There was actually a new house was being constructed right next door. Once the concrete was poured, then there was no need for the barrier tape. And then subsequently to the concrete being finished, Mr. Shaliga's crew appeared. Appellate has gone to great lengths to show that Mr. Johnston's role was some sort of supervisor. He wasn't at this project. He ordered materials, he made some recommendations as to vendors, and he picked up a building permit.
Didn't
That's
he
it.
appear occasionally, at least, at the work site?
Oh, yeah, he looks like he
saw
appeared twice that week.
He saw the hole in the flooring, right?
Yeah, he claims that he saw the hole in the floor. He said that I told him, hey, you guys should better cover that up, or something to that effect. By the way, none of the Shaliga crew ever remembers him being there and saying that. But let's assume that he did say that. He felt powerless when asked, why didn't you stay and correct it, make sure that they put the cover on? He testified, he didn't have that authority. It wasn't Mark Cerrone's job. And that's why he didn't. Certainly, with all the years' experience he had, and he testified, if that would have been a Mark Cerrone Inc. job, there would have been subcontracts, there would have been contracts, there would have been a work order, there would have been a project assignment, there would have been weekly meetings, there would have been an OSHA report.
Labor worker, it would have been labor unions involved.
Oh, there would have been labor unions involved. There would have been, OSHA standards. Somebody was seriously injured on this job. Cerrone would have followed up on that.
Do you agree with Mr. Gorski that the court applied the wrong standard in its decision?
Yeah, well, I think in its decision, the court didn't mention the words authority or the control of it. It mentions they didn't exercise the control.
Yeah.
But, as this court is well aware, this court's scope of review of a non-jury trial is as broad as the scope of review of the trial court.
So you want us to look at the evidence and apply the right standard even though Judge Steeder applied the wrong one?
Correct. There's nothing further. Thank you, Your Honor.
Thank you. We go to case 364, is Coe versus Village of Waterloo. 364.
Good morning.
Good morning, Mr. Adams.
Afternoon. Please the court, Dan Adams for the appellant. The issue presented today for the appeal court is whether a landowner's use of artificial means, in this case piping, to direct surface water from his or her property onto their neighbor's property constitutes a continuing trespass.
And we have a case called EPK, as you well know, cited in the Supreme Court's decision. That was the subject of much discussion in your briefs. I think you also cited our, what's the other case? It's Webster.
The Webster, I think the Webster, well, I'd like to talk about both of them. I think they're the ones that have to be discussed. I agree, Your Honor.
And Capruso is, I think, cited in EPK from the Court of Appeals. So we know what cases we have to look at, and we have to decide whether or not the Supreme Court got it right on the continuing wrong doctrine. That's basically it, and I don't mean to steal your thunder, Mr. Adams.
You are 1,000% correct, Judge.
It's a pretty straightforward legal issue, and if we can link this to a particular time, a particular act, then it's probably an affirm, and if we can't, then it's probably not. Am I close?
You're certainly close, Your Honor, and those are the cases to talk about. And if I could have a moment or two, I'd like to talk about my view of those. I'm glad to get rid of everything else. The one thing I would say, however, in case there's any doubt in the court's mind about the extent of changes made on the construction project, if you go to R381 and 382, you'll see drawings showing the existing condition versus the new condition. I just want the court to be aware of the extensive changes that were made between the existing drainage system, which was a 3 by 3 foot stone culvert box pipe, versus what is in there now, which is a pretty extensive network of large bore PVC piping connecting to at least 5 and perhaps 6 catch basins that are called drain inlets on the drawings, all of which now direct the water to a manhole directly across the street from Mr. Coe's property. The village then comes in, opens the street, puts new piping in, PVC piping, connect the new manhole into a manhole that is in the right-of-way directly abutting Mr. Coe's property. From there, the village then takes a piece of PVC pipe, they jam it into the existing stone culvert pipe on Mr. Coe's property, and they put concrete around that to seal it. So I just think it's important to understand there's a fairly significant change in the surface drainage.
Shortly after those changes were made, your clients experienced flooding. Your client experienced flooding on his properties that he had not previously seen.
Yes.
There seems to be a cause and effect there. Of course, the issue is should he have sued within the year, within the a statute of limitations starting in 2015.
Right.
Of course, he's waited a bit, and that turns on whether this is a continuing trespass or not. And the case that I thought that you cited, which seems favorable to you, is the DiMarzo case from 2002 out of this court. That's what we called it, a continuing trespass. We seem to have gone in another direction though since then.
I don't think you have, Judge. I think the Foles landfill brothers case, I think that's being misapplied or misconstrued. So in the Foles, just so we understand, in the Foles case, you had the Foles landfill that was the subject of the remediation plan because of CERCLA. Now, in reading the decision, what you know is this. You know there's a strip of land between the plaintiff's property, NIMO owns a strip of land, then there's the landfill from Foles Brothers. So there's some question there about how water was directly onto the plaintiff's property when there's a strip of land between the two of them. The second thing I think is really important, though, is that the actual remedial plan itself, the way it's described, is that it was put in a way where water was channeled away from the adjacent properties, and it was channeled to an existing stream and wetland. There is absolutely nothing in that case, judges, court, that here it is here, that indicates that artificial means were used to direct water from the Foles Brother landfill property to the plaintiff's property. There's nothing that says that. And we have to remember, there's a whole set of case law out there that says a landowner has the perfect right to improve their property. And if the result of that property is that water ends up on their neighbor's property that wasn't there before, that's not actionable, unless artificial means are used or there's some kind of bad faith in what they did intentionally in some manner. So you have a right to do things. So Foles Brothers, under law, under CERCLA, had to do something. But again, there's nothing to say that what they did directed water onto the plaintiff's property, and to assume so, I believe, has put us in the position we're in right now. You have to be able to show artificial means were used in order to direct that water over there.
All right, so you're saying EPK properties is distinguishable, there was no artificial means there was here?
Yes.
Okay.
Oh, here, yes, without a doubt. Well, there's nothing in the Foles Brother, what it tells me is just to the contrary. It says that the defendant Foles Brothers Landfill Site Steering Committee oversaw the design and construction of the remedial action, which included a surface water management program to channel water away from adjacent residences and streets. According to the remedial plan, the surface water was directed toward an existing wetland and ultimately to a nearby creek. That's what it says in that decision. If there's other facts out there, I don't know what they are, and I haven't been presented with them. So I have nothing to show me that artificial means were used. I think that the Webster Golf Course case, I think, is an excellent illustration of this, and I think it's important that this case come up, because I do believe that this continuing use is not being given the weight that the court has always given it. In the Webster Golf Course case, the complaint there was that the defendants did some reconstruction on their property. And the result of that was that harmful silt was deposited into the plaintiff's retention ponds that they use in their golf course. That happened on 2 occasions. It was in May that happened 2 times. And so the court said, in that case, I can point back to what had happened. It happened back then. It's not happening today. You have no evidence it's happening today. So it's not a continuing trespass. And I agree 1,000% it's not a continuing trespass. The other thing to remember here, to kind of crystallize it for me, was that when the county and the village installed all of their vast piping network and all the new piping, everything they did, the installation of that pipe with nothing more is not actionable. There is nothing about that pipe or those catch basins that is a trespass or a nuisance. The county has every right in the world to do that. What they can't do is once water, their surface water, enters that pipe, that's where the trespass occurs. The pipe they put in is on their own property. I can't complain about that. But I can complain about the water every single time it goes in that pipe and gets transferred onto my client's property. That is a continuing trespass.
Even if it doesn't cause flooding on your property, your client's property?
Well, there has to be some kind of damage, Judge.
Right.
I would agree with that.
So you think the statute of limitations should run the last time there was flooding or damage from this? It doesn't have to go back to 2015.
Well, actually, Judge, I'll take that back. Look, you can have nominal damages, right, in trespass. We can still have an action. So I would offer to you, Judge, that there was a trespass occurring this past weekend. Right. When it rained for 3 or 4 days, anytime that water, they have no right to put their surface water on my client's property. They have no right to make
without damages.
Well, I guess you're right. Without damages, well, it'd still be nominal, Judge. There's nominal damages in any nuisance or trespass case, which would at least allow us to an injunctive relief. So what we have now is a situation where the county and the village now could just throw their water on my guy, and he's just got to deal with it. And I think it's also important to remember that the county and village did absolutely no analysis whatsoever of what they were tying into. That, and I have my testimony in the record from my expert. He ran a closed circuit, camera through the pipe. That pipe, we don't know how old it is. It's at least 100 years old. Appears on no drawings. It's in no right of way, no municipality right of way at all. And what we have found, we don't even know where the outlet is. All we know is that when we go through that, the camera had to stop because it had collapsed on itself in a few locations. There was dirt and earth that had piled up, and the camera couldn't get through. So what my engineer is telling me is that the water is ponding back up. It is finding its way to the surface, probably, most likely through two drains that Mr. Coe has on his property that is part of this. Comes back up through that and damages it in that way. So that, I guess, Judge, is what I'm saying. That's the damage. There has to be, I suppose, nominal damages, but there is, Judge. The other damage here is that the county is using Mr. Coe's property. They're using it for a purpose. If they don't use his property, they've now got to relocate that pipe. They've got to do something. Or they've got to come to us and say, you know what, can we use this for you? Can we use your piping system? They don't just get to use it. No trespasser gets to just use it. And there's case law out there, Judge, on the damages. One thing to point out, the trial court did not rely on any kind of damage on his decision. But there is a lot of case law out there. Some of it says that the trespasser shouldn't benefit from what he does. And so the damages are based on what the value is to the trespasser. And I would offer to you that we have evidence, or at least testimony in the record in the form of an affidavit from a professional engineer that says it would cost upwards of $650,000 to do this right. They didn't do that, so they saved all that money, and they just have it dumped on my client's property. There's an interesting case that I have in my reply, Zutt v. the State, and I took the quotation out of the miscellaneous, the Court of Claims decision. I will also say that that decision was affirmed by the Second Department, but it was affirmed on a prescriptive easement allegation, whether or not the state had prescriptive easement. And that had to do with a culvert pipe that the state had in place, and they had then, it was installed in 1928. They replaced it with catch basins and pipes in 1984. The plaintiff brought an action, I believe, in 2001. What that judge said, that Court of Claims judge said the discharge of water onto the claimant's property here was trespass in 1928 when the culvert was installed. It was a trespass in 1984 when catch basins and pipes replaced the old system and clearly increased the speed of any discharged water. It is a continuing trespass and nuisance through the date of accrual of this claim on June 17, 2001. And that's really the crux of what my argument is. And it's also what this court has said in DeMarzo, and nothing in Fold Brothers changes that. One final thing is there's some reliance on a Copart case, v. Wright, out of the Western District of New York. That's a report and recommendation from a magistrate judge. My understanding is there was a text from the district judge that approved it. But anyway, my point in bringing it up is that it has absolutely no precedential authority whatsoever on this court. It's not even from a district judge, it's from a magistrate judge. And also in the Copart case, the vast majority of that Copart case dealt with a situation where it's commercial properties. They were redoing their parking lot. And as a result of everything they did, the plaintiff complained about water coming onto his property. And the courts rightly said, hey, he has a right to improve his property, sheet drainage isn't actionable. However, there was one pipe in the back corner that led from the plaintiff's defendant's property into a retention pond on the plaintiff's property. And in that case, there was the plaintiff said, well, sometimes the water gets in there to the retention pond and it backs it up and it doesn't work right. Whether or not there was proof of that, there seemed to be some question about the proof. But, and that was the one spot of that case where after throwing out the rest of it said, and I'm not going to give you that either, I think it's saved on Fold Brothers. So I think Fold Brothers is being misconstrued. You cannot use, otherwise you have a situation today. Mr. Coe has to deal with this every day it rains. And why should he have to deal with that?
I guess their argument would be, well, he could have sued years ago, and then he would have had his day in court. That would be their response to that. Why does he have to deal with it today?
I suppose that's a response, Judge. It doesn't change the fact that if there's damages anytime, once they do that, whenever that damage occurs, it's actionable again, Judge. Right. Every piece of water is a new trespasser. So every drop of water is trespassing.
So this action could be litigated like 100 years from now?
It could be.
200, whatever.
Could be, but it's not.
As long as the culvert is still there.
Yeah, I mean, if you took it out to its logical extreme, certainly. In this case, it brought in 2021, I believe the case was initiated, when he was trying to get subdivision approval, and they said, well, you got to take care of some drainage issues here in the property if you're going to get subdivision approval. That's what the engineer says in his affidavit. That's why it came to fore.
Right.
But I don't think that the damages have, I don't think the exact date of damages has anything to do with the fact, it has to do with, what you say, the continuing trespass. The whole theory, as we know, is that it's a new trespass every time it happens.
Gotcha. All right, we'll take a look at it. Thank you.
Thank you.
You are Mr. Connor,
Yes, Your Honor.
and you represent the
The
village?
Village of Waterloo.
Thank you.
Good morning, Your Honors. May it please the court. I want to quickly address what I believe are the two major cases in this case, the EPK case, also referred to as Fowl, and the Webster case. First for EPK. Now, the plaintiff, the only distinction he makes between EPK and the current case is that the decision in EPK does not refer to a artificial diversion of water onto the plaintiff's property. But, Your Honor, now while the appellate decision may not have referenced that fact, if you go back to the original order that case was decided upon, it specifically states in here, Your Honors, it is undisputed that there are artificial means used to divert the water onto the property.
Do you know what the artificial, do you know what they are in that case?
I believe there were some drainage pipes, Your Honor, or I am not sure of the exact means in that case, but I don't think the exact means are as relevant as the court stating that in that case it was undisputed that there were artificial means used to direct water onto another property. So the only distinction that plaintiff makes between the EPK case and the current case is based off of faulty information, as finding from the original order from the Supreme Court in that case.
What do you make of the DiMarzo decision?
I think DiMarzo, any decision in that case is overruled by subsequent case law. The case law following DiMarzo has been consistent on that it is not a continuing trespass.
So what would be a continuing trespass? Could you give me a situation in a water diversion where it would not, where it would be a continuing trespass?
Your Honor, if if the diversion of water is not traced to a specific objectionable act as this court held.
Right.
So if there was subsequent work done to that drainage pipe that increased or allowed that water to continue to drain, then that may be a situation where it is not, it may be a continuing trespass.
So wait, explain it to me. So there's some work done, water goes onto the plaintiff's property, then you're saying it's continuous if the property owner then does something else again on their property? Does more work that leads to water?
I believe so, Your Honor, but that would be a different situation than we have here.
It would seem like there's no continuous trespass there, like, ever. Like, it's just, if we follow your argument, then we're doing away with the whole concept of continuous trespass, it would seem.
Well, continuous trespass in these specific situations, perhaps, but that was the holding in the EPK case, and I think Webster does a better job of illustrating the difference. In the Webster case, this court found, or the holding of that case, was the doctrine of continuing trespass may only be predicated on continuing unlawful acts and not on the continuing effects of earlier unlawful conduct. That is the situation in this case where the only alleged unlawful conduct was the village and the county's work on the courthouse and the village's retrofit of the tie-in. Again, Your Honor, the village in this case did not construct a new tie-in to the culvert under Mr. Coe's property. That tie-in was already existing. They merely did a retrofit of that tie-in.
Mr. Connor, let me interrupt you real quick.
Yes.
A thought just came to mind. But on DiMarzo, and I looked at it earlier today, I may have this wrong, but I didn't see any discussion of the statute of limitations or continuing wrong concept in DiMarzo. Did you? I know the language continuing trespass was used in DiMarzo, but theoretically, you could have a continuing trespass that's time barred, or you could have a continuing trespass that's not, depending on when the plaintiff sued. So even though it's continuing, if it's attributable to a particular act, the wrong that Webster talks about, if you can detect when it started, then that measures it for the continuing wrong toll, as I call it. I think that's the wrong word, but having to do with the statute of limitations. So DiMarzo, I don't know that it is a continuing wrong statute of limitations case. I think it does use the word continuing trespass, and the Justice presiding has raised a lot of conceptual things here that make this very confusing here, in a way. But when you also look at the Webster language that you were just quoting, and I focused on that as well, that is, the distinctions between a single wrong, which I think conceptually could create a continuing trespass. But if it's attributable to a single wrong that has continuing effects, or there's a series of independent, distinct wrongs. So that's the question we have to look at. Your argument is this is an independent, distinct wrong that occurred in 2015, irrespective of whether it's a continuing trespass or not. That's what activated the time to sue.
I would agree with that, Your Honor. Again, what that traces back to is, again, that 2015 work that was done by the county and the village. That is what the plaintiff alleges caused the flooding at every stage in this litigation, from the notice of claim right up until his deposition testimony. And even today, in oral arguments, counsel alluded to that work. In addition to that, sorry. Nope, never mind, I lost my train of thought, Your Honors. Apologies for that.
That happens when we interrupt you every 2 seconds, so that's on us, not you.
All right, I'd just like to quickly focus on the injunctive relief argument here. The case law has been fairly consistent that injunctive relief is a remedy that is based on the validity of the substantive claims, and here the substantive claims are not valid because they are time barred under several cases, most notably EPS and Webster. If the court has no further questions, I'll rest on the remainder of my papers.
Thank you, Mr. Conlon.
Thank you.
Good morning, Your Honors. Brian Biggie on behalf of the county. I just want to refocus, I think, taking a little bit with what Judge Kern was addressing. Arguments about liability and impacts on the property don't address whether this claim is still timely. The question is, can the plaintiff get around the statute of limitations? And I would submit that the plaintiff cannot. The reality is that these are consequences of an initial discrete discernible act. And under EPK, it is simply untimely. To answer your question, Judge Lindley, an example where this would be a continuing trespass. In EPK, I believe the decision from Bloomingdale's is referenced. And in that case, the court found there was an ongoing trespass. But consider what happened there. In that one, the plaintiff's pipe was cut by the defendant, which was running, I think, forgive me if I get this wrong, north-south, and they put in another pipe that was running east-west. And as a result, it caused a water backup. That was their pipe. They physically impacted it, damaged it, cut it, and as a result, there was a water backup. That pipe continued to exist in its form until it was discovered by the plaintiff. The plaintiff didn't know that was the cause of their water backup. They thought it was something else. It was only after it was excavated that they determined it. In that case, the court said there was an ongoing trigger. There was a continuous condition because that trespass, that physical pipe on the property existed from the day it was installed all the way to the day it was detected and or removed. So in that instance, there was a trespass. Here, we're talking about someone that's downstream who's isolated a specific change that resulted, and again, counsel said it today, in 2015 they had flooding. This isn't a scenario where there's some unknown hazard, some unknown defect. Plaintiff was aware of it in 2015.
They were aware of the flooding in 2015, and importantly, in your view, they were aware of the cause of the flooding.
Exactly.
Because that would be part of the analysis, right? If you, just because you have flooding, you have no idea what's happening, you can't be expected to sue somebody.
Right. I think the
So
record,
it sounds like when I was looking at DeMarzo, I had the same thought that maybe there is a continuing trespass nuisance that still exists. Maybe this is. It doesn't necessarily follow that there's the statute of limitations isn't as the court here said. When you have a continuing trespass or a regular trespass, if there's damage and you know where it comes from, and it arises from a single act, a single wrong, then even with a continuing trespass, because the water keeps coming, the statute of limitations for a continuing trespass is, as the court said here, within a certain period of time of your knowledge of the single act of wrongdoing.
right. And consider too, I mean, plaintiff's counsel's statement towards the end as to plaintiff's motivation, right? He's not suing because the property was damaged in his basement. He's suing because he's tried to develop the property, and now it's going to cost him more to do so because of the water impact, right? So he knew this was going on since 2015. It wasn't impacting him for years, and now it presents a financial impact for his development. He's saying, wait, I want to go back now and initiate this suit, and it's still going, so I can, as you said, Judge, I can sue in 100 years if I want to, because every time there's a lot of rain, I get a chance to do it. I don't think that's the intent of the statute of limitations or the exception. But again, that's what plaintiff's trying to do here. This isn't a liability argument. This isn't a volume of water argument. This is, can I demonstrate a basis to get around the statute of limitations? And I would submit that plaintiff can't do so.
Mr. Biggie, please extend our sympathies from the court to Mr. Lerner's family.
I will do so. Thank you, Judge.